The title of the class for this week is Internet Governance, Physical Territory, and Markets. Last week, we considered whether voluntary standards, social norms, and code can comprise forms of law in cyberspace. This week, we will extend that discussion by further examining the role played by territory and markets in Internet governance. As the materials for this week suggest, many scholars are skeptical of the claim that cyberspace is a unique place that could govern itself, while others continue to believe that cyberspace represents a kind of commons. We'll come back to the political and economic theory underlying this debate at the end of this lecture, but for now, let's look at a case currently before the Federal Circuit that highlights how these issues play out in concrete circumstances of the modern digital economy. ClearCorrect v. International Trade Commission. First, a little background. The United States International Trade Commission is a federal government agency first established by statute in 1916. The ITC provides reports to the President and Congress regarding U.S. international trade policy, and also serves as a quasi-judicial forum with administrative law judges who can resolve international trade disputes. Among the areas within the ITC's purview are intellectual property, unfair competition, and antitrust claims relating to imported goods. A party who believes its intellectual property is being infringed through the importation of infringing goods can ask the ITC to conduct a Section 337 investigation, named for Section 337 of the Tariff Act, through which the ITC can issue an exclusion order directing U.S. Customs to stop infringing imports from entering the United States. In recent years, the ITC has become a popular forum for patent owners because its standards and procedures are perceived to be faster and more flexible than an infringement claim in federal district court. This has particularly been the case in the electronics industry, where patent aggregation entities, also known as patent trolls, accumulate large numbers of method and component patents and then seek to hold finished products coming in from China or elsewhere for ransom. The practices of these PAEs, or trolls, is controversial and has provoked substantial litigation and lobbying activity. The ClearCorrect case involves method, computer program, and device patent claims for orthodontic treatment. The owners of the patents, Align Technology, is not by any account a patent troll. It produces the well-known Invisalign orthodontic appliances. The technology covered by the patents involves creating digital scans of the patient's teeth and constructing clear plastic appliances based on the scans that move the teeth into proper alignment. The clear plastic appliances are thought by some patients to be preferable to more traditional metal braces because they are more comfortable and less noticeable. The respondents in ClearCorrect include a U.S. company and a Pakistani company. The U.S. company makes a digital scan of physical dental molds taken by an orthodontist. The digital scan is transmitted by the U.S. company from a server in the U.S. to the Pakistani company. The Pakistani company, using computers located in Pakistan, produces a series of digital models of appliances needed to gradually work the patient's teeth into proper alignment. These stepped digital models are then uploaded to the U.S. company's server. The U.S. company loads those models into design software, which allows a 3D printer to produce physical models of each step of the realignment. These physical models are then used as casts for the clear plastic aligners, which are provided to the orthodontist. Why does ClearCorrect complete the intermediate modeling step on computers located in Pakistan? According to the ITC, this is an effort to skirt U.S. patent law. And this is why the ClearCorrect case is so interesting. The ITC claims that the uploading of a digital file from Pakistan to the U.S. is the importation of an article under the Tariff Act. ClearCorrect and the amici who filed briefs siding with it argue that the transmission of data over a network, including over the Internet, is not the importation of an article. The ITC does not have jurisdiction over U.S. or international telecommunications policy, much less over the Internet, but the IC does have the authority to block the importation of infringing articles. The key word in the statute is article. From a historical and textual perspective, it may seem that ClearCorrect and its amici have the better argument. Under both U.S. law and international law, there are other bodies of law and other administrative agencies that regulate various aspects of telecommunications infrastructure, such as the FCC. The ITC's purview, historically and textually, seems to be trade in more traditional kinds of products. Except, the statute does give the ITC authority to block the importation of articles that infringe U.S. patents, and patents themselves are intangibles. If ClearCorrect and its amici are correct, a possible implication may be that the ITC has no jurisdiction over patent issues where the infringing conduct is not at least in part embodied in a physical object. That is, the ITC may have no jurisdiction at all over method patents. For those who think patent trolls are a major problem, this may be a good result. Unfortunately for that view, the Federal Circuit ruled en banc this past August that the ITC does have jurisdiction over allegations of induced infringement of method claims. That opinion is Suprema Inc. v. ITC, available at 2015 Westlaw 471604. It's unclear exactly how Suprema may relate to the issues raised in ClearCorrect. Aside from the interesting issues of statutory interpretation and administrative law raised in ClearCorrect, you should note it as a fascinating example of how the borderless world of cyberspace may or may not be borderless after all, and of how cyberspace may or may not relate to real space. The technology in ClearCorrect reduces the physical structure of a person's teeth to digital information, which can be compressed and communicated across the globe over the internet, manipulated and reincarnated in physical models. If this infringes a patent, where does the infringement occur? Is there an importation of an article across borders? Or are there just exchanges of information in cyberspace? International trade law and intellectual property law don't seem to map comfortably onto these sorts of questions. As we noted in last week's lecture, these difficulties are part of the reason why most cyberspace exceptionalists think existing legal structures simply should not apply in cyberspace. But aside from a handful of cyber anarchists, most of these exceptionalists realize that something must structure human conduct in cyberspace. Last week, we looked at the notion of code as a kind of law. Now we'll discuss the governance of markets, or at least of a kind of market activity. When we talk of markets, we usually have in mind a strong view of property rights along with a strong view of the freedom to contract. The original Chicago School view of law and economics, for example, thought that, absent some kind of specific market failure, resources would be allocated most efficiently through voluntary transactions. The Austrian school also values strong property rights and freedom to contract, but focuses more heavily on the role of the individual and is suspicious of economic models suggesting market failures. Some cyber exceptionalists are libertarians whose ideas incline toward Chicago or Austrian economics. But there is another way of thinking about markets, evidenced in the work of Nobel Prize-winning economist Elinor Ostrom, that emphasizes the importance of political institutions and social norms. This school, sometimes called the New Institutional Economics, derives some of its ideas from the Chicago School, particularly from Chicago luminary Ronald Coase, but describes circumstances under which collective action, without defined property rights, is more efficient and productive than the more individualist Chicago or Austrian schools. The new institutionalist perspective is embodied in the open source software movement and in related open source or peer production movements. Your reading this week contained materials from a leading scholar working within this framework, Yochai Benkler. The open source software movement stresses that software source code, that is, software code that is readable and editable by humans, should be open for anyone to see and use. Open source code, the theory goes, is better code, because a broader group of motivated people are able to improve, tweak, extend, and modify the software's security and functionality. An open source project can function with no intellectual property rights at all, but more often open source projects use intellectual property law to ensure that the project remains open. For example, the code may come with a copyright license that allows users to freely modify the code, but that requires such modifications to be published along with the same license for other users. This is called a viral license. Open source models have been fabulously successful in some areas of software development. Elinor Ostrom has shown that similar norms obtain in a variety of economic settings, such as traditional fishing villages, in which no individual owns property rights in the fishing grounds. Theorists such as Yochai Benkler argue that open source or peer production models can and should apply to a far wider range of economic activity. Benkler suggests that the Internet facilitates the widespread disaggregation and distribution of many kinds of work, and that such disaggregation and distribution would limit the power of big corporations and governments, increase individual satisfaction and productivity, and produce greater net benefits than traditional property-based models. In short, Benkler offers an economic model in which norms of cooperative production are the primary structure of governance. The open source ideal, however, is easy to state but harder to implement. In particular, it can be difficult to determine how, if at all, the open source principles developed in the software hacker culture can transfer to a different technology. The process used to make this determination involves breaking the technology into components or layers, then examining whether any given component is a good open source candidate. The starting point in this analysis is Benkler's 3 layers of a communications system. These are the physical layer across which the information travels, the code layer that makes the physical layer run, and the content layer of information. The hardware code content paradigm provides a useful means of analyzing many technologies beyond software or the Internet. For example, in his book The Future of Ideas, Lawrence Lessig describes how those layers apply to various traditional modes of communication, ranging from Speaker's Corner in London to the arts, books, and music. In each area, it is easy to tease out different layers that may be either controlled or open. After the appropriate layers have been identified, each layer must be examined to determine whether that layer is an open source candidate. In his work, Benkler concludes that a technology must possess 2 characteristics for open source or peer production to be feasible. First, the project must offer social psychological rewards that will attract collaborators. Second, the project must be divisible into small parts, such that any individual collaborator's investment is small. Benkler suggests 3 characteristics of divisibility. 1, the project is modular, meaning that it can be broken into asynchronous components. 2, the modules are fine-grained, meaning that each module is manageably small. And 3, there is a low cost to integrate the modules. Benkler's criteria are a good start. However, modularity, granularity, and social psychological rewards are necessary but not sufficient criteria for open source production. In my article, which I have not asked you to read, The Penguin's Genome, or COES and Open Source Biotechnology, I argued that a viable open source model also requires a particular community with at least 3 characteristics. 1, there must be a pre-existing community with norms of sharing and collaboration in which the social psychological rewards are rooted. 2, there must be authoritative voices within that community who add value to the rewards. And 3, there must be authoritative voices within the community who catalog and publish individual contributions to the project. Moreover, as other legal scholars have argued, open source norms can only develop within a legal framework supported by certain sorts of license terms. In particular, as we've noted, open source licenses usually include covenants that run with the code to ensure that the code remains perpetually open. As you read Benkler's work, then, consider whether it requires a more traditional substructure of authority and law after all. In more precise terms, Are new institutionalists such as Ostrom and Benkler really on to a new insight that can be leveraged dramatically in cyberspace? Or are they merely describing something Chicago School economists, including Ronald Coase, recognized all along? Market exchange can efficiently allocate goods and services if structures exist to limit market failures, such as monopolies, externalities, and high transaction costs. Are externalities and transaction costs in cyberspace naturally so low that they tend to take care of themselves? Or are there certain kinds of externalities and transaction costs in cyberspace, such as the need to protect rights in physical infrastructure such as tubes and servers, or the need for security, that open source models cannot overcome? In the Chicago School model, it is precisely these sorts of costs that usually suggest a need for some kind of governmental intervention. This is also the position taken by Tim Wu and Jack Goldsmith in their book, Who Controls the Internet? Whether there are such unaccounted for costs in cyberspace is one of the big issues in Internet governance.